18CV27149, Byers versus Dyke. And looks like I've got Mr. Tissot on behalf of plaintiffs. Mr. and Ms. Dyke are both also present. Just a little housekeeping before we get to the meat of the matters today. Obviously, we've got somebody video recording. They were granted permission, went through the process to do that. Simply because one person's been authorized to video record doesn't mean that anyone else can or can engage in what we call electronic writing, typing on a computer or a smartphone, that type of thing, or sending any recordings or sending electronic writing from the courtroom. I would refer you to the UTCR that deals with that if you've got any questions about it. That's 3.180. The person who was granted permissions agreed that they're knowledgeable about that rule and the limits imposed by it, and have agreed to abide by that rule. Anyone else is prohibited from recording audio or video. And again, may not send either from the courtroom. Certainly welcome and free to request a copy of the audio if you'd like to do that. Okay, I think that gets us to the point where we're set to deal with our motions. I had requested that we set this hearing so that we could address a variety of motions that were filed since our last hearing in hopes of keeping the summary judgment hearing that we had scheduled at that time. I'm trying to recall what date we had that set for. It looks like January 8th. Given all the filings recently, I'm not entirely sure we're going to be able to hang on to that date, but I'm going to try. So we're not addressing the summary judgment today, at least not directly. We've got a couple of motions that are sort of related, both filed by defendants. The first is a motion to conclude the September 19th hearing in defendant's favor, and the second, which is related, I think, defendant's motion for estoppel regarding substitution of counsel document. Mr. Dyke, you can deal with those in either order or whichever order you prefer. I have reviewed them. Do you have anything else you'd like to add by way of argument?
Well, an example of the confusion is supposedly the plaintiff's attorney substituted on September 3rd. And on the 16th, he was supposedly busy effecting an assignment agreement, unawares to Rosa OSTROM, who was at the hearing, despite the September 3rd signature date substituting counsel. She was at the hearing on the 19th. 3 days prior to that, Mr. Plaintiff's attorney, Mr. Tissot, I don't know if he was officially the attorney. We're confused. Is it the 3rd? Or was it when we got the paper? Nonetheless, she was here in apparent total ignorance of what he was working on. And as you know, we wasted a half hour haggling over possession. And possession obviously changed with his motion for summary judgment and this assignment agreement, settlement agreement. So this is the kind of confusion that I'd like to address.
How would you propose we address that any more than you've highlighted in your motions?
We mostly want to be on record that we object to the whole mess of it regarding substitution of counsel.
Okay. I think you've made that pretty clear on the record. Mr. Tissot, any response to either of those motions?
From our perspective, the substitution occurred when it was filed. And not before.
Anything else? No. Okay. So with regard to the motion to conclude the hearing in defendant's favor, it's clearly based on defendant's belief that plaintiff failed to appear at that hearing because Ms. Ostrom appeared, and that there was this substitution of counsel that had apparently been signed but not filed. I can certainly understand that position, given that the substitution of counsel is signed September 3rd and contains language that says it's effective immediately. However, there's a couple of different issues we've got. going on there, and I'll try to just boil it down to the most direct. The issue really is resolved by ORS 9.390, as well as, I think, some common sense. That statute makes it clear that the adverse parties, the defendants, are bound to recognize the former attorney, which would have been Ms. Ostrom and her firm, until they're given notice. And that makes sense because obviously if the notice was truly effective immediately when it was signed, they, as well as the court, would have no idea who they were supposed to be dealing with. So it's effective by that statute when the notice is given. From my perspective, that means it's effective immediately when the notice is given, not when it's signed. So Ms. Ostrom was effectively the attorney that both the defendants and the court were bound to recognize. Otherwise, we'd have no way of knowing who we were supposed to be dealing with. So I don't think that that means that plaintiff failed to appear at that hearing. Additionally, plaintiff can be represented by more than one attorney at a time, doing different things or even working on the same case. So I can't find that the plaintiff failed to appear, so I can't grant that motion. So I'll deny that motion. With regard to the estoppel motion, I think that's really based on the same issue as when this notice was effective. And I also don't see, at least at this point, anything that I could apply an estoppel remedy to. Certainly there may have been some confusion, and I think it would be appropriate where those circumstances arise, it has some impact down the road, to be able to consider that, and I certainly think it would be appropriate for the court to do that if there is some impact. But I don't see anything at this point that I could apply an estoppel argument to. Mr. Beck?
It's on record that the attorneys involved in this case have created no end of confusion, and they've attempted to exploit that confusion. And furthermore, I think it's inexcusable for an attorney to be here in ignorance of the other attorney, what he was doing.
And you may be correct that there's some issue there. I don't think there's an issue that impacts our suit. So I would deny that motion as well, and that moves us to the motions to compel. The first is a motion to compel discovery set 13, which I've identified the right discovery set. That was a request for documents and things evidencing plaintiff's response and action to the for sale sign posted on parcel B, the disputed piece of property. Mr. Dyke, again, I've taken a look at your motion. Do you have anything else you want to add to that?
Just to state for the benefit of the people here, in this property dispute.
Mr. Dyke, you're welcome to address the folks in the gallery when we're not on the court's schedule. We do have limited time today, so any argument you need to make needs to be related to the motion.
It's our position that the plaintiff gave every appearance of abandoning the property. And you tell me a reasonable man that would allow a for sale sign on his property for 3 months and do nothing about it. So we would like to discover if there were communications, what the truth is about why this for sale sign was allowed on a property. We are trying to get at the truth of this case.
Mr. TISSOT, what's your position with regard to that particular motion?
Well, we've made a number of objections, and we've also provided responsive documents. I don't know what he thinks is missing, or he refuses to indicate what he thinks is missing.
You believe you've provided anything responsive to that request?
I do.
Mr. Beck, are you aware of anything that you believe or have reason to believe exists that's responsive to this request that you don't have?
There could be, obviously there was probably communications regarding the sign, and maybe that's protected, maybe not.
Communications to whom?
Between the tenants and plaintiff buyers. This is very unusual behavior.
I would agree with you that if those documents exist, they would be responsive to that request, but that doesn't mean that they exist.
We're trying to compel production of those.
Okay. Well, they've indicated that they've produced all the responsive documents, so there's nothing to compel.
We know of no responsive documents received or provided.
Do you know of any responsive documents that exist?
I'm trying to explain ones that might exist.
Okay. Might exist doesn't get us to a motion to compel. If they say that they've produced what they have,
Which is nothing.
or that none exist, the burden then is on the party seeking to compel to establish that documents exist that are responsive that haven't been produced.
Am I allowed to search a plaintiff's computer? I mean, how do I get at things legally other than discovery? Besides breaking into people's offices and looking at their computers.
Which I wouldn't recommend. Given that they've indicated they've produced all the responsive documents, I would deny that motion, which moves us to 14, which was a request for... Yes.
Which RFP are we speaking of specifically?
It's identified as set 13 was the one that we just dealt with. This is the one identified as set 14.
And what was the language in the RFP 13?
13 is documents and things evidencing plaintiff's response and action to for the for sale sign posted on parcel D. And the example that Mr. Dyke gave was communication. It would have to be in writing, electronic writing, I suppose, between your client and his tenants that said something about the for sale sign. You've indicated that you're not aware of any such document.
So I believe what I've sent to Mr. Duck is correspondence that I sent to Wasco Title, correspondence sent to, Wasco Title, I think is the main thing. And then, of course, the letter that I sent to him were the actions that we took. Also, I think the request is incredibly broad, and
Objection.
we made the objection based on that as well.
I believe a reasonable man can understand the nature of the request.
Yeah, I'm not sure that I find that the request is overly broad, at least that one. Okay, so then we move on to 14, which is documents and things evidencing plaintiff's physical presence in the Dalles from March 1st to August 1st of 2018. And it looks like the plaintiff objected to that one on the grounds that it was overly broad, unduly burdensome, seeks documents that aren't relevant or reasonably calculated to lead to discovery of admissible evidence. Mr. Beck, why do you believe we need to compel those documents?
Unfortunately, the court has not been able to reckon possession in this matter. So the lease isn't good enough, apparently, for the court to reckon possession. So I'm trying to find things that prove, like I have been all along, actual possession. If he has no record of any transaction here during this time, that seems to indicate he might live somewhere else. And he does not dwell at 326 West 21st. I'm forced to dream up every type of angle to establish actual possession. And the lease is not good enough. So we can't compel the man to come here, apparently, and state anything.
I'm confused about a couple of things. One, you say the lease is not good enough. I'm not sure what you're referring to there. There haven't been any evidentiary determinations with regard to the possession issue as yet. But I'm also not clear how his mere physical presence in the Dalles establishes one way or the other his possession or right to possess that property. How would it do that? Say, for example, he's got a receipt from something he purchased at Home Depot here in the Dalles. How does that tell you whether or not he's entitled to possession of the property?
Lacking for, Your Honor, lacking for any other evidence other than the lease, you said on the 19th that utility bills should be forthcoming. Instead of providing those, as you agreed to, the plaintiff's counsel now has been busy with other things, where 2 months later, utility bills have not been forthcoming.
And while utility bills might somehow fit into this request, I'm still not seeing how his mere physical presence in the Dalles establishes an element either of their case or of your defense.
His attorney said he was here up until the time that this dispute erupted. So if he was here, he should be able to present some shred of evidence in support of that.
I would agree with you to that, but that doesn't answer my question about how does that evidence support either one of your defenses or one of the elements of plaintiff's claim?
I'm trying to gain as much truth as I can about this. If there's no evidence he was even here, that adds to my case that he was not in possession.
I'll defer to the court. I don't know how to respond to his objections.
Yes, Mr.
In light of recent material produced, some of this, I think, is largely going to be found to be irrelevant and a waste of time. I think it'll be found that the whole period of time that we've been haggling over possession is probably not of ultimate value.
I assume you're referring to the assignment.
Assignment, MSJ.
So I'm going to deny this request. I do think that it's overly broad. Again, I don't think his mere presence in the Dalles establishes either one of his claims or one of your defenses. There may be some subset of documents that would fit within that request that would, and if you can identify that, you're certainly free to request those. Which moves us to the motion to compel 15. It requests documents and things evidencing storage agreement or contract the plaintiff used to assess storage fees for claim 3. It looks like the response from plaintiffs was that there were no responsive documents, which I assume means that there's no agreement or contract that they used. Is that accurate?
That's correct.
If there are no documents, Mr. Dyke, what can I compel them to produce?
We have been trying to get to the truth of damages for 18 months. None have been forthcoming. The only shred of support for damages apparently comes out of his imagination. The plaintiff's imagination that if he were in the storage business and had other people wanting to utilize the storage services, then, well, if he were in possession of the property, which he isn't, he would have been entitled perhaps to services rendered as a storage business. We don't know of any storage business there. A normal storage business has the overhead of security, insurance, on and on.
So let me back up and ask that a different way, perhaps. It sounds like you've got some criticisms of what you believe plaintiff's evidence will be, his testimony, and you're certainly entitled to that. But if they don't have any documents responsive to this request, I don't think there's anything for me to compel. Okay.
Fair enough. We just went on record that we attempted to address this.
I think we've got that clear. So then let's move on to set 16, which requests documents and things evidencing Daniel Byers' place of residence and place of business for Dan Byers Construction during 2018. And it looks like plaintiffs objected on the grounds that it's overly broad, unduly burdensome, seeks documents which are not relevant or not reasonably calculated to lead to the discovery of admissible evidence. Mr. Tissot, I'll let you respond to that request first.
I don't have anything more to say other than where his business is located has nothing to do with anything.
Objection.
Well, we need an objection at this point. Nobody's giving evidence. Is there any allegation that his business or his residence were located on this property?
No, that's not our
Objection.
That's not our position.
What's the objection, Mr. Mayor?
Historically, his residence and place of business has been the same place. When he was here,
When you say the same place, you mean this piece of property, or just that they've been
formerly,
located?
Mr. Byers' business and residence was at 326 West 21st Place. And now we contend he is at a different residence and using that same address for his place of business.
Okay. I'm wondering if perhaps we can't reach a stipulation that resolves this issue, because I'm thinking that, I just went through a whole bunch of paperwork that I've gathered over the course of a year to shred it and get rid of it, and it filled about 3 garbage bags. So I'm imagining there could be a significant amount of documents that would establish where Mr. Byers' current residence is and where the location of his business is. It would seem to me that that probably is overly broad and unduly burdensome, but I would also not want to put Mr. Dyke in the position of attempting to disprove that the disputed property was his residence and business if that were to be, for some reason, the position he took at trial. If we could reach a stipulation that during the time period in question, neither Mr. Byers nor his business were located or residing at the property?
Yes, I think we would stipulate that during the relevant time, meaning in this case would be the trespass,
Right.
that he was not residing in the Dalles.
Objection.
What's the objection?
This attorney has clearly stated in a demand letter that the plaintiff was in possession of the property and entitled to the quiet enjoyment of it. And that furthermore, the damages were against him, thus constituting a defective demand letter and a defective lawsuit.
So without getting to that, we'll get there in a moment. I think this stipulation resolves what you're looking for in this particular request. And the stipulation, as I understand it, that during the disputed period, so during the period of the alleged trespass, that Dan Byers was not residing and did not have his place of business in the Dalles. Does that address the issue that you were trying to get with this request?
Your Honor, if we can add in the provision that the demand letter and claims 2 and 3 are fundamentally defective, then we might consider that stipulation.
Mr. Tissot?
No.
I assumed that was going to be the response. So, Mr. Dyke, where we're at is I need to either address your motion to compel on 16, or we can agree to the stipulation of evidence that during the disputed period, Mr. Byers was not residing and didn't have his place of business in the Dalles. You willing to accept that stipulation?
Your Honor, I don't think we're willing to accept that without counsel. We would like an opportunity to counsel on that before we agree to any stipulations.
Okay. Well, then I've got to deal with the request to compel, which I am going to deny at this point is overly broad, unduly burdensome. Again, given the amount of documents that fall into that, I'm going to deny the motion to compel. Which then moves us to defendant's motion to dismiss claims for failure to state ultimate facts sufficient to constitute a claim. Pull that motion up here real quick. And that is specific to claims 2 and 3. Mr. Dunn?
If we were to agree to the stipulation we just discussed, would that enable you to go ahead and grant our motion to dismiss?
No, and I can explain why once we've dealt with the motion to dismiss. Is there anything you wanted to add by way of argument with regard to your motion to dismiss?
Absolutely, Your Honor. I highlighted this time from Boyer versus Anduze. It is a general rule in America that either actual or constructive possession is sufficient to maintain trespass, although one of these two kinds is necessary at the time of trespass. Standing by reason of a contrived agreement after the time of trespass does not affect standing at the time of trespass.
Anything else?
For the record, from our research, issues of standing can be addressed in a motion to dismiss. However, the court disagreed with that. So if you could offer any explanation, if you could state for the record that standing cannot be addressed in a motion to dismiss, we would like to have it on record.
Mr. Tissout, any response?
Unless the court has questions, I'll rely on the brief. First of all, the motion is procedurally failed on a number of issues. An important piece of this is for the movement to state that they're not doing it for the purpose to annoy her.
Objection.
Go ahead, Mr. Tissout.
And many of his motions, I believe, are exactly for that purpose to
Objection.
harass.
Mr. Dyke, I'll give you a chance to respond.
And so it seems to me particularly relevant that he has failed to assert that. If the court has any other questions.
Where should authority, I mean, obviously, folks aren't supposed to file motions that are intended to harass or annoy, but is there actually a requirement that that be listed in a motion or a declaration supporting one?
Yes, I believe so. I think it's stated in the motion, in my response.
Objection.
I had some assistance from my